Today I'll talk about a Delhi High Court decision concerning Bry-Air Prokon SAGL and Others versus Union of India and another. A writ petition was filed by the petitioners. The petitioners are a part of Power Group. That is, there are 3 petitioners. So the writ petition challenges the impugned order by the Controller of Patents, whereby patent applications filed by the petitioners were deemed abandoned as well as lapsed due to non-filing of timely response to the first examination report, and also on account of non-filing of the renewal fees. The petitioners had appointed the first patent agent for prosecuting and coordinating these 6 applications and a granted patent before the granted patent which is lapsed before the Indian Patent Office. So basically, the petitioners wanted the first patent agent to periodically report on the status of the pending applications as well as the patents, and also intimate the petitioners if any action was required. These are the patent application numbers in the lapsed patent. So the issue was identified in the case of a national phase application by European associates. So an FER was issued by the Indian Patent Office on March 22nd of 2018. Due to not filing response to the FER within the stipulated time, the application was deemed to be abandoned on April 4, 2019. The European associates working for the petitioners, they happened to check the IIM-Pass website and inform the first patent agent about the abandonment, who in turn took a position that they had not received the FER. Then the European associates, so subsequently the first patent agent informs the European associates that they had sent a formal letter to the Indian Patent Office intimating the non-receipt of the FER and requesting for the reissuance of the same. Subsequently, correspondence was exchanged between the petitioners, the first patent agent, and the foreign associates. And all through, the petitioners were given the impression that the first patent agent was actively pursuing the matter at the Indian Patent Office, and that the delay was due to the ill health of the Indian Patent Office and the limited functioning of the Indian Patent Office on account of the COVID pandemic. The petitioners then get suspicious and decide to transfer the power to prosecute and process the applications and the patent to a new agent in January 2022. And the new agent happens to inquire with the Indian Patent Office if the FERs for the applications were sent to a correct email address, and they were informed by the Indian Patent Office that they were indeed sent to the correct email addresses. Upon confrontation with the first patent agent regarding the negligence in prosecuting the applications and the patent, the first patent agent admits his negligence. And so the petitioner's contentions are that they have a long association with the first patent agent since the year 2012, and they had a reasonable expectation that he would comply with the standing instructions of the petitioners for prosecuting the applications within the stipulated timelines and the deadlines. The petitioners also contended that based on the information given by the first patent agent, they were made to believe that the first patent agent was meticulously following up the matter with the Indian Patent Office, including the steps for restoration of the patent applications and the patent, which was evidently not the case. The petitioners place on record the entire correspondence, which includes letters and emails exchanged between the petitioners, the foreign associates, and the first patent agent. And so the rules and sections relevant to this case are first Rule 138, which talks about the power of the controller of patents to extend time prescribed in the rules for a period of 1 month in certain cases. And one of the exceptions is time for meeting the deadline under Section 21. That is time for filing the response to the office action. So the prescribed time limit is 6 months from the date of the issuance of the FER, with further extension of 3 months. Then the other relevant rule sections are concerning the restoration are Section 53, Section 142, and Section 61. So in summary, when a patent is granted after the expiry of 2 years from the date of filing the patent application, the renewal fee becomes due within 3 months from the date of the grant of the patent and within the extended time period of 6 months. A patent granted in India lapses when the patentee fails to pay the renewal fee within the given time. The patentee can file an application to restore the lapsed patent within 18 months from the date of lapse or cessation. So the issue here is, can abandoned patent applications and lapsed patents be revived or restored, taking into consideration all the rules and sections that I just mentioned? So in this case, the court relies on 2 judgments, European Commission versus Union of India and Ferit Alani versus Union of India. Based on these cases, the court observed that the patent applications were deemed to have been abandoned on account of the negligence of the patent agent in not filing reply to the FER within the stipulated timelines. And the contention of the applicant was that despite continuous follow-up, the patent agent had not responded and the delay was not attributable to the applicant. Also, the petitioner sought continuation of delay in filing reply, contending that valuable rights in the patents had been lost for no fault of the petitioner. The court observed that while exercising writ jurisdiction, the courts have extended the time for filing response to FER in extraordinary situations where patent agents were found to be negligent in prosecuting the patent applications with no contributory negligence of the applicant, and on showing that the applicant had a positive intent to prosecute. The court also observes that abandonment requires a conscious act on the part of the applicant, which would manifest the intention to abandon, and no presumptions can be drawn in this respect. Further, the court observed that deemed abandonment of the application for grant of patent leads to serious impact on the valuable rights of the patent applicant, which flow in favor of an invention. And this is compounded by the fact that under statutory scheme, there is also no appeal provided against order of deemed abandonment under Section 21 of the Act. So the court had observed that for each case would require examination on its own facts and circumstances to see the intent of the applicant to abandon. So based on these analysis, the court decides in favor of the petitioners, and the applications for which the FER reply was not filed within the stipulated time, the court orders the applications to be restored to original positions, and the petitions have been allowed to file the response within a period of 4 weeks from the date of the decision. And in the case of the lapsed patent, upon the petitioners filing restoration application within 4 weeks from the date of decision in a prescribed format and also with the payment of prescribed fee, the patent office was directed to consider the revival or restoration of the patent in accordance with the Act and rules. Thank you.